Good morning, fam. This is mrstsoloane, aka Mrs. T. Welcome back to my channel and thank you for the continuous support, or welcome if you're new. Please do consider clicking down below the red subscribe button. It's free. This morning it's about 4:45. I'm on my way to the airport. I'm attending an event hosted by the author of You're Not Broke, You're Pre-Rich, Mako. I am so excited. I've been waiting for this event. I wish I could scream, but it's very early in the morning. However, I'll try to capture as much as I can because I do want to be attentive and present for the event as I'm traveling all the way to the Botanical Gardens in Sandton. See you later.
Good morning, everyone. Good morning. Thank you so much for coming.
Thank you.
You guys are amazing. So our first conversation today is around law, around marital contracts. Who's getting married here this December? There we go. Love all the time. But the conversation that we leave out is, okay, baby, you're right, I love you, but how are we going to do this? Right? From how are we going to handle our finances as a unit? What commitments do we have outside of the family that we are starting together? So today I have the beautiful Kundi, and I'm going to share you there, say or encourage, if you were to at all, someone to get married in mutual property, or is it one of those contracts that say you really have to know your stuff?
To be honest, Mapalo, it's a case-by-case basis because currently, right now, we're giving general advice,
Yes.
right? And that's why before you get married, it's important to see a lawyer and discuss what your circumstances and your fiance's circumstances are to get the best solution. I did give an example of where in community and property works. I know a lot of our parents are married in community and property, and also times were different then. Right now, we are side hustling, we are trying this and that, and you don't want, should something like that fold, that now you are putting your house with your husband and your kids in jeopardy of being sold to satisfy debts of your business, for example, which is not necessarily the life that our parents lived before us. So it really depends on the times, the people, and how you are. But if you're pretty sure that, for example, you will be at home and economically you're not going to be at the same level as your husband or your wife, then maybe in community property is a way for you. I don't know if I should unpack the other two.
Alright, before we unpack the other two, I just wanted to go back also to say, if you are getting married, you said if it's lobola and you have completed the process, are married. But when should someone come and see Kunti before they get married? When is it a good time?
Before your family even meets. Okay, and I'll explain why I'm saying that. It is the safest way because one, cultures are different, and also even though like in Venda, but like what we do in Joburg versus what happens in Venda may be different. Fana people, etc. And we also the double HP case. So in some cultures, that first meeting is considered that you are married now. And a lot of people after that meeting go off happily, moving together, etc. In some cultures, the family only considers you married after that second meeting, where you dress up ramecha and there's the welcoming of the bride, you know. So to avoid any grey areas, and we do find these cases where you can go to the High Court afterwards and prove that you were married or not, but you need money to do that, you need a lawyer, etc. So rather to be safe, as soon as he has proposed, as soon as that finger's gone and we posted that whole thing on Instagram, which I get,
The easiest idea ever.
yes, go then and see a lawyer. Just go with your fiance, explain your circumstances, get legal advice, and then you can see what marital regime will work for you. So don't wait.
All right. So we are talking about money. How much is it to see a lawyer to explain all of these things to you?
It depends. I mean, come to me. I'm kidding, but yeah, it really depends. You just have to do your research and get quotes from different lawyers. It depends on level of expertise, how long you've been doing that kind of work for, etc., and that will determine the rates.
Okay. Yeah. All right. So go to you before, literally after the proposal, that's the conversation we should have.
Yeah.
All right. So can we move on to out of communal property with the accrual system and outside of the accrual system? So you can just explain those two to us, then we can ask some questions around that.
Sure. So as I said, after 1984, then the accrual system was introduced. So first you could only choose in community and out of community. So out of community or property, you have two options. You can be married in what we call out and out. So that's out of community or property with no accrual. And that's the simplest marital regime you can enter into, in the sense of what's mine is mine, what's yours is yours, and never the two shall meet. Okay, so you don't have a case of a joint estate. You actually have two individuals and your estates are seen separately in that way. So for example, let's have Kim and Carl, right? Kim comes into the marriage and she's coming straight from home. She's just starting her career. She doesn't have anything. And Carl is a trust fund baby. He's got 2 million rands worth of assets, which comprises a house and investments, for example. And they get married out of community of property. Their estates remain separate. When they buy their house, if Carl is the one buying the house and he registers it in his name, it will continue to be his. When he buys the couches, etc., everything remains Carl's, right? Upon dissolution of the marriage, should they get divorced, and he meets a younger foster version, I will name names with like a young influencer, for example, and then he says to her, okay, actually, like, please leave the house and leave the Range Rover keys behind, and my credit card and everything. He has the right to say that because the estates have never met, and she can leave with nothing. All right. We'll come back. There is a remedy available for her, and also in the community of property scenario that I mentioned here, there are remedies, so just remind me afterwards. But to get to those remedies, again, you need lawyers and the court, etc. But that's out of community of property.
So on the out of community of property without the accrual system, so let's say Carl and Kim, they are buying the house together. On the dissolution of the marriage, what happens?
So if the house is registered in both of their names, and they're both contributing to the bond, for example, or the upkeep of the house, they would need to enter into a separate contract regarding the house to say that we are co-owners of this house, and should we get divorced or separated, then the house either needs to be sold and liquidated, and then the proceeds are divided between the two of them. One of them would remain in the house and have to buy the other one out. But you have to get into.
So this is another contract on top of the contract that you signed.
Yeah. If you want to be safe, should things fall apart.
Yeah.
But I do want to mention that out of community of property, there are instances where it is good. So for example, if you're both very economically active, you're both working, whether or not you have kids, but you're on the same level, it's the easiest way because you can get into business transactions. You don't need the other partner's signature. You can get into debts during the marriage, and should anything go wrong, they can only look at your estate and not your partner's estate, for example. And should you get divorced or separated, everyone goes their own way. Oh, Konjanak, Karakile couch, TV, I take them. You bought the Le Crusade set, you take that, and that's that.
So in instances, I'll give you an example. When I was studying my CFP, the lady was facilitating it. Says she was very young when she got married. Very, just loved the partner so much. When they got married, the partner's parents said, "Okay, here's a contract that you're going to sign." Right? She signed it. She didn't know what she was really signing. It was okay. It's a contract to make sure that you're just here for love and not for money. Right? She built up her assets way more eventually. Right? When the marriage dissolved, this husband said, "No, but I supported you in all your endeavors. I made sure that I was the primary caretaker of the kids." And in situations like that, what happens? You got married on mutual property. How do the courts remedy something like that?
Yes, so there is a remedy available. However, let me explain with accrual, and then the remedy will make sense. Okay. So that is out and out. And then your third option of getting married, which is now the popular one and the one that sort of addresses redistribution like that, is out of community of property with accrual. Alright, so still the estates are separate, there's still no mixing of estates like this. However, at the end of the marriage, what we look at is the growth in the two estates. So if we look at Kim and Carl again, Kim came in with nothing, right? So we start in her ANC contract, antenuptial agreement, it will have a no balance because she had no assets. Carl came in with assets worth 2 million, so that will be stated in the antenuptial contract. At the end of the marriage, we look at how the estates have grown. Let's say Carl's estate has now grown to 4 million because he's doing well in business, etc. And Kim has remained at home and her balance is still nil. So we look at the difference. The difference in Carl's estate is 2 million rand. And there's a CPI adjustment that is done with that, and that's where we get financial people like you to assist us as lawyers and numbers. And then we look at the difference, and then the spouse with the smaller accrual, meaning the smaller growth or no growth at all, can share in half of the growth of the other partner's estate. Okay.
So we'll share in the 2 million and not the one that they brought in.
Yes. Okay. Because what you come in with is stated so that it's excluded. And then in the marriage, because it's taken that whatever he's managed to grow in the marriage was with the support of Kim. Whether that support was financial, whether it was in kind, whether it's just saving costs by not having to have au-pairs, etc., because she's there for the kids, that contribution is taken into account and she can share in half of the growth of his estate. So that is generally the system that, as you were asking me in the beginning, that is considered to be wise under our, in our day and age. Now, because the accrual system was introduced in 1984, the courts were of the view, and according to also our legal precedents, that if you still chose to get married out of community of property, out and out, after 1984, you had the choice to choose accrual, but you chose not to. And then you come back crying afterwards to say, but I was at home and I did A, B, C, and D, and I'm leaving with nothing. You don't have a remedy, right? Because you could have chosen to go with accrual. And that's where that interesting case has come up, which,
Yes. So the case is that they were married out of age of property. Was it with accrual, without accrual?
It was without
accrual. So out and out. Yes. Right? And now the case is that, okay, the courts looked at it and said, you know what, to be fair and equal, let us redistribute some assets from the husband. How does that work out? We got into a contract, right? And getting into a contract says, I'm aware, I know what I'm getting myself into. How do the courts come back and say, yes, we know that you got yourself into this, but you're going to do something else? How does that work out? And what does it mean going forward, especially for people who are married out of community property without the legal system?
After 1984, great question. So there is a remedy in our law under the Divorce Act, and that's Section 73 of the Divorce Act, right? If you are married out of community of property before 1984, and then you're saying that I've stayed at home, like the example that I gave you, and Kim now has to leave all the keys of the cars and she has to go back home, basically. There's something called a redistribution order or redistribution of assets. that you can ask the court for, but it's very difficult to get this order. You have to show that it would be inequitable and unjust for you to leave under the circumstances. And also you have to show that the duration of your marriage has been quite long and there are other factors that the court can take into account. But the court would not entertain that application if you got married after 1984 because they are saying that you had the freedom of choice when you entered into the contract. So in this interesting case that went all the way to the Constitutional Court and was actually decided on the 10th of October, Kralen versus Minister of Home Affairs, the wife in this case said, look, I've been with this guy for over 20 years now. I've contributed to this marriage in kind. I've supported him in his endeavors. He's a very successful businessman. I'm leaving with nothing and he remains with everything that we've put together. And she said it's discrimination based on dates, basically, that I can't request this redistribution order because I got married after 1984. Yes, I hear that you're saying that I had the freedom to choose, but also one thing that hasn't been taken into account is disparity. Even when we go to see our lawyer, you know, as the fiancés, let's say it's hubby who's paying for this consultation. He's made the appointment with me. You know that he's paying. You know that he's coming from a trust fund family, and you don't want to seem like someone who's after the money. So you're very quiet in the consultation. You're not asking all the questions you should, and all of that hasn't been taken into account. And the court said, taking all of that into account, that generally there is a weaker party in the negotiations. We can't discriminate based on date. And now, whether you're married out of community property before 1984 or after, you can still ask for a redistribution of assets at the end of your marriage, but you should be able to satisfy the court that you meet the requirements. And you can't have been married for like a year and yeah. So yeah, that you raise the kids and all the examples.
So it must be 10 years plus.
There is no number, but the court looks at your circumstances holistically. And also you can't be, yes, I was at home, but I spent all my days shopping for Santa City. And that can be shown in statements that you weren't really assisting. There were nannies, there were au pairs, and so you didn't really. So it's a very in-depth investigation into how you did contribute, but that contribution definitely is recognized. And it doesn't always have to be a monetary contribution.
All right. Yeah. So now talking about, there is American content, then there's South African content, right? Because people often say, no, they get 50,000 rent a month from the ex-husband, right? Does that apply in SA? Do people actually, if it's not for children, for the children's upkeep, do women or men get some sort of maintenance, if you can call it that?
I'm glad you asked that, which is very important. So now we get into the realm of maintenance, which is separate from your marriage contract. So a spouse can request upon dissolution of marriage to say whether you're married in community, out of community, or out of community with accrual, whether or not you're entitled to half the estate or not, you can raise the defense to say that even during the divorce proceedings, you are able to pay for a lawyer and counsel. I can't even pay for a lawyer because I've been at home the whole time. We've cut off my credit cards. How am I supposed to defend myself in that matter? So we have remedies in law, like what we call a Rule 43 application, which is to say, while we are dealing with the divorce, in the interim, can the court give an order that he or she must pay the other spouse's legal fees during that process and continue to pay, well, you keep me out of the house, so can you pay for my rent, medical aid, car, etc. And courts do grant those orders. That may change at the end of the divorce once the court has had time to look at the matter and see what you're going to get in terms of your marital contract. But yes, maintenance is definitely something that can be asked for. I see a lot in the media lately that radical amounts are being asked for, and I think you're right that sometimes you see things on American TV and it's not the case here. You need to show that this is the lifestyle that you've been used to, but also you can't be 28 or 35 even and say that this is the lifestyle I'm used to and she must continue to pay for that, because the court's going to say you are You look great, you are able to go out there, you are healthy for yourself. You have an education. If you don't, you can go and study. He can pay for your studies, and then the maintenance will last maybe for about 5 years, then you must now look after yourself. So your application, for example, would be different than a 62-year-old woman. So that's also something that's available. And child maintenance and spousal maintenance are two different things.
Yeah. Okay, I think we'll get to child maintenance afterwards. I want to talk about a controversial topic.
Okay.
Marrying more than one wife. Right? How does the contract? Because if I got married to you and they came to my house, my lobola, and now you tell me, oh no, I want a second wife. I mean, you hear it all the time now all over social media. How does the court decide on that? Can someone get married again to someone else after they've been married to me?
It's a mess when it comes to division. I don't want to lie. Unless it's a very reasonable person who's going to be fair and equitable to all the wives. But in terms of our law, the first marriage is the one that's recognized, right? And like I said to you, whether or not you sign home affairs, this thing of the wife, she's still a wife according to the law. So any subsequent marriages that you enter into are not necessarily registered, because in South African law, it's one civil marriage that is recognized.
But let's say they did the lobola, then you stayed at home, he came somewhere to Johannesburg or he moved to Dubai, right? And you never signed anything. But by South African law, you say we are married, right? But I'm somewhere else and Home Affairs doesn't have anything on the record that I'm married. I can go to Mpo here and say, Mpo, I love you, let's get married. And Mpo knows these things. No. We're not just going to do that. We're going to go actually sign and go flex.
Okay.
How do you deal with that?
So again, the first wife who doesn't have papers, you can go and prove that you were married. But again, you want to not be in a position where you have to prove it post facto, because then you need the resources to do that. So what she would have to do is go back to her family, get those letters and whatever was signed during the lobola process, go to a lawyer, a formal high court application has to be made to first recognize the marriage, because there's even people that want to get divorced. But before you can even get divorced, because then the husband is now denying that you were ever married because there's no piece of paper. So before you get divorced, you must first go to the High Court and make an application to show that you are married, and that's a process on its own. And once you have the order confirming that you are married, then you can start the divorce process, right? Because people try to run away from it because of the automatic incommunity of property. So the best advice would always be, even if you've done your lobola negotiations, etc., you know you married in community property, so you don't have an antenuptial contract, get the marriage registered so that there's no need afterwards to have to now prove against your husband that you're actually married. It can be done, but it's a process and it can be a costly one.
All right. Yeah. So on the lobola and completed the thing, now you're married. And I'm looking at people, normally people tell me, okay, Mapalo, we did the whole lobola thing before we saw a lawyer. So now we are married, but can they still come back and say, hey, we didn't do it right? Can we come back to you and say, can we do an antenuptial contract?
You can, that remedy is available, but again, it has to be a high court application, a very expensive one, because you have to first inform both of your creditors. Because remember, your marital regime doesn't just affect the two of you, it affects your creditors in terms of whatever debts you have, etc. So let's say you're converting from in-community property and you now want to be married out with accrual.
Yes.
So you'd have to serve the notice on all of your creditors. They need to be given a chance to object or not to object. And then that high court application is then made by a lawyer, and then the court can then decide. So it has been done, it is doable, but it's a long haul.
And is it expensive?
It can be quite expensive depending on the process with the creditors. So with lawyers, I mean, you're getting charged per hour. So the longer your matter drags on for,
the more.
Yeah.